Okay, so without further ado, let's please have the first speaker of the proposition side.
Thank you. I will start my speech in 3, 2, 1. Dear debaters, today I present to you a play worthy of the likes of Shakespeare and Molière. That play's name is the International Criminal Court. As do many other institutions, the ICC appears at first glance to be a force for the good and the just. Behind the scenes, however, the International Criminal Court is but a patchwork of corporate buzzwords, unfulfilled promises, and globalist idealism. Understanding this and leaving the dark cave of ignorance has led this House to this conclusion. International Criminal Court's member states should withdraw from it and form their own regional courts. How are we going to define this transition in the debates? In a few short sentences, the aim of our policy is for individual states to leave the global courts and concentrate their efforts on creating regional courts based on criteria we will elaborate, or reinforce existing courts like the Court of Justice of the African Unions. Before I dismantle the tenets of the International Criminal Court, it is fair to acknowledge the noble goal behind it. The court made its appearance in a time where people were waking up to the atrocities and bloodshed of the Rwandan genocide and the Gulf Wars, a time where trust in Western institutions led to a desire for said institutions to promote their values overseas and crack down on barbarism and needless conflicts. However, that concession leads me to my first arguments. The International Criminal Court has been an effective institution. Therefore, member states should withdraw from it. First, the ICC lacks any law enforcement capacities and relies on member states to perform arrests. This hinders its ability to exert any real power over people it prosecutes and leaves that responsibility to member states that may or may not subscribe to the supposed impartiality of the courts. This is reflected in the fact that the court has only convicted 10 people in 20 years of existence, despite there being at least 15 other fugitives wanted on war crime charges alone. If individual nation states with armed police forces still struggle to enforce and convict criminals, then an international organization without any military force is essentially an acting set. Our policy simplifies this process. In fact, moving military personnel through a smaller array of nations is simpler, and a regional court intrinsically gathers like-minded nations. What do we mean by that? In essence, a nation would only agree to delegate part of its judicial power to other nations if its ambitions align with that of the other nation. What that entails for our motion is that regional courts require a level of harmony in order to be worthwhile. On the opposite end of the spectrum, it is impossible that the 124 members of the ICC share the same ambitions. Now, a second problem that compounds over the ineffectiveness of the court is its funding. If the ICC is only a shell of its promises and ambitions, then any amount of funding it receives contributes to passivity and weakness. In their reports, Understanding the ICC, the institution admits that a vast part of its funding originates from member states. It is akin to pouring money down a drain. Now then, this problem increases in severity when you consider that many of the members in the courts are impoverished nations where the rule of law is feeble and anarchy reigns. A nation such as Niger ranks in the world's lowest caliber when it comes to the rule of law, according to the ResearchGate, yet expends its limited resources towards funding an organization that will not benefit it in any way. When you look at it that way, the International Criminal Court is reprehensible for theft. In our model, regional courts will allow nations of a similar socioeconomic level of development to collaborate in law enforcement. This equity calibrates the regional court's activity, which means that individual member states have more say in the proceedings and can fund the court based on their needs. For example, a nation such as Nigeria would fund a regional court more heavily than a nation like Botswana, because the former struggles with terroristic activity within its border. As an additional measure for equity, a smaller regional court like the Inter-American Court would be able to better represent countries through judges because of the smaller scale of the courts. For a global judicial organization like the International Criminal Court, focusing on individual cases rather than holistic developments is a very difficult task because of the scale of the activities, leading to the dilution of any efforts undertaken. Now, if you shine the funding of the court through a prism, another grave phenomenon unravels. The inequality between the funding capacity of different nations produces an asymmetry of power within the international criminal courts. In fact, a large part of the organization's budgets come from those nearest to its headquarters in The Hague, aka Western Europe. Having a near hegemony on funding allows these nations unprecedented power over the courts, i.e., reducing funding when justice diverges from their ambition, and increasing funding when justice aligns with their ambition. That manifested itself when the courts refused to prosecute ecocide. Is it a coincidence then that Denmark, Norway, the Netherlands, and the UK are all large producers or refiners of fossil fuels? We think not. This bias of the International Criminal Court leads us to our final arguments. The court is a tool for neocolonialism. Indeed, while the court claims to have a global mandate, it took until January of 2016 for it to open its first case outside of the African continent. Meanwhile, conflicts raged in Nagorno-Karabakh, Afghanistan, Israel-occupied Palestine, and Sri Lanka. The fact that these cases went unnoticed by the court points to a clear bias the organization has for Africa. It operates as a tool of control, siphoning power and funds away from impoverished American nations while producing negligible results. In fact, it may even have the opposite effect, igniting more conflict than it extinguishes. According to the sociologist Kermarik Daniel, African criminals held culpable by the ICC were more likely to conduct bloodshed and violence than their counterparts who received an arrest warrant from national or regional law enforcement. Actually, this was the case for former president of Sudan, Omar al-Bashir, who caused a civil uprising before his ousting from power and arrest by the ICC. However, let's say that hypothetically, the ICC only focused on Africa, counterintuitive to their globalist message, of course, because the African continent was rife with strife. This argument can't hold up since much of this strife originates from Western intervention. I'd like to point to the NATO assassination of Libyan President Muammar Gaddafi, which plunged the nation into a terrible civil war and led the ICC to sign an arrest warrant for Tuhami Khalid, a Libyan war criminal who gained power after the fall of Gaddafi. The case then appears one-sided. Western European nations stir up conflicts in poor nations, then they use the channels they have themselves funded to bring peace. Can't you see that it is a method of control and neocolonialism? We propose that instead, like-minded nations make their own rules and their own justice. Without intervention from malicious agents, such an institution would be leagues ahead of the ICC in terms of effectiveness. Now, to finish this, I'd like to ask one thing from the opposition. How can you defend such immorality? I've finished my speech.
Thank you very much. The speech time was 8 minutes and 27 seconds, so it was under the 8 minutes and 30-second mark. By the way, guys, I'm just saying the speech times after all of your speeches because the coaches are going to be watching this a little bit later, and it's just easier for them to make, to know how long your speech time is. So don't think I'm being weird by just saying the speech times, whatever. Okay, so let's continue with the first opposition speaker. Please give your speech whenever you're ready. And guys, don't forget, POIs are highly encouraged.
Sir, can you hear me?
Yes, I can.
Okay, so I'll start now. Imagine executing a 6-year-old child because the said child is not a productive citizen, because the said child has no utility to his or her environment, because the said child is still benefiting from the nation and not the opposite. The truth is that a child has not yet started having utility and has not yet started serving their nation. The child is in their development phase. And this is the case for the International Criminal Court. Ladies and gentlemen, the ICC was created in 2022. It is only 20 years old, and it has accomplished so much during its short life. And now, Imagine that that child is the first human on earth, and that other beings are expecting the absolute perfection from them. And that is also the case for the International Criminal Court, which is the first international court in history with jurisdiction to prosecute crimes against humanity. First, I'll be answering my opponent's arguments, and then I'll be presenting our team's argument, which is the fact that the ICC is not racist, as they were referred by other organizations, or even self-referred, also because of some non-African countries' reluctance to ratify the treaty because of fear of persecution. Second, the ICC is effective as proved during the ad hoc tribunals. Third, it has a great impact on, never seen impact on humanity. First, my opponent talked about the ICC focusing on impoverished countries and the fact they have alleged double standards. The International Criminal Court is not institutionally racist. The ICC involvement in African issues have been referred in some cases by the UN or even self-referred by a member of states, which was, for instance, the case with Uganda and the conflict with the Lord's Resistance Army, which is a rebel group which operates in northern Uganda and other countries. This means that the nations themselves asked for the ICC's involvement. So the ICC did not even act without being asked to, and therefore it can't be racist. Also, the ICC deals the most with African issues. It's because other nations with alleged human rights violations are not members or did not ratify the treaty. So the ICC cannot be involved as the ICC does not operate in non-state parties or have its own police force or enforcement body. Thus, it relies on cooperation with countries worldwide for support and make an arrest, transfer an arrested person to ICC detention center, and can only work with the help of the specific country collaboration, as opposite of African nations who are in fact involuntarily state parties, without forgetting to mention that human rights violations soar across Africa. Based on reports, Africa is the continent with the most human rights violations. Also, the ICC has other non-African situations under investigation, including Georgia and Colombia. Another proof that the ICC is not institutionally racist is that the USA, Israel, and China voted against it. And elaborate. As far as America is concerned, the ICC has no jurisdiction, no authority, and no legitimacy, Trump said during the General Assembly in 2018. And that's because of the alleged crimes and atrocities perpetrated by US in Afghanistan. George W. Bush also was against ratifying Rome statutes, as he was afraid of the possibility of American soldiers being targeted by the international community. A powerful country such as the United States can only, sorry?
Points of information.
Yes.
Isn't an international criminal court ineffective if it cannot act against the war crimes of the biggest nation on earth? Most powerful.
Well, the ICC is doing their best. They cannot go against international law and start interfering. They do not have enforcement. They do not have an enforcement body. They cannot just go and act and go against the international law, because the other nations who in their countries they have like worse violations against human rights. They did not ratify the treaty, so the ICC cannot go beyond its limits. A powerful country such as the United States can only go against the ICC because they know it will not overlook or deliberately ignore the atrocities the USA has done. So the ICC does not deal with these important human rights violations because they illegally cannot act against the international law. It can only act within its limits. That's what I mean, dear opponent. And that's why they are not racist. It is just a change that the majority of virtual cases happen in Africa. And the same goes for Israel, whose opposition to the treaty stemmed from the inclusion in the list of war crimes, the action of transferring population into occupied territory with Israel has done. Another and final example is China, who has been particularly concerned about the ICC's potential interference and its policy and ability to address possible requests of extremists, separatists, and terrorist violence and human rights violations toward the Uyghurs in Xinjiang and Tibet provinces. Not to mention the mass arbitrarity detentions, family separation, torture, and religious persecution, which conclude that Chinese authorities have committed crimes against humanity. So China knows that if they ratify the treaty with the ICC, they will definitely acknowledge these human rights violations and therefore act on them. The ICC can prosecute individuals, and that's probably one of the key points for which some big nations like the United States, China, and Russia are part of this treaty. So the reason why the ICC may focus on African states is because they are safe members. Therefore, the International Criminal Court are in fact doing their best while respecting nations' choice to ratify the treaty or not. And victims, including Africans, should have recourse to justice. The ICC has limited its jurisdictional power, but it can act. It does act, and this happens to be in Africa. Next, my opponent said that the ICC is not effective, and that's simply wrong. The ICC is effective. While work began on the test and drafting in order to create the ICC, the United Nations Security Council established 2 ad hoc tribunals. Ad hoc, which means impromptu, so done without the preparation, and specifically for the purpose of the specific topic in questions. The first ad hoc tribunal was the International Criminal Tribunal for the former Yugoslavia, created in 1993 in response to a large-scale atrocities committed by armed forces during Yugoslav wars. And the second is the International Criminal Tribunal for Rwanda, created in 1994 following the Rwanda genocide. These two tribunals were so successful that they promoted the creation of the ICC, and this tribunal's role and mechanism is exactly one of the International Criminal Court. So if these tribunals are efficient, it is more practical to create one International Criminal Court in order to assess in order to address all world issues and crimes. The ICC has been criticized because of its alleged ineffectiveness, slowness, and ineptness. And yes, the first judgment of the International Tribunal for the former Yugoslavia was delivered 4 years after the creation of the court. But why my opponents failed to acknowledge is the meticulousness of the prosecution's office activities, the judge's decision, the prosecutor, etc. If the court takes time to deliver judgment, is to so that they can be precise. And nobody would agree with the only body of international the only body of international justice to be unjust. Dear opponents, it's your choice. Judge quickly or judge better. Finally, the International Criminal Court has never seen impact on humanity, and that's our first argument. Dear listeners, while watching news and televisions about wars, criminal war conflicts between nations, genocides, and heartbreaking human rights violations, didn't we all wonder and wish for a non-biased, independent external party who will solve the issue and give victims their rights and rightfully deliver judgment? Well, this is exactly the role of the International Criminal Court. It is an independent judicial body with jurisdiction over person charged with genocide, crimes against humanity, and war crimes. And if the ICC cannot act freely, that's because of the principle of complementarity, ladies and gentlemen, which is based both on respect for the primary jurisdiction of states and the consideration of efficiency and effectiveness, since states will generally have the best access to evidence and witnesses and the resources to carry out proceedings, and these states can only be biased. So instead of withdrawing from the ICC, nations should cooperate more so the result of the ICC judgment be optimal, and that needs more time. There's a quote from the ICC's ex-president, Silvia Fernandez: "International criminal justice is a long-term project, and therefore it is much too soon to give up on the ICC." And so far, it's doing more than good than harm by prosecuting the recruitment of child soldiers in the first case with Thomas Kabaga. It has sent strong messages that the world condemns such crimes. National, original, or even continental systems cannot be optimal for international crimes, because a continental or regional court would disregard their opponent's official capacity and leaders to commit crimes, and that refutes the other argument that we proposed. Then it cannot be left up to the continental court system to judge. Therefore, an international court is necessary if regions were capable of implementing criminal justice anyway. We wouldn't be having this debate today. So, dear opponents, your idea is mistaken. Also, some countries within regions do not even agree on the creation of a continental criminal court. For instance, African states themselves are divided on the African Union desire to withdraw en masse. Certain states are resistant to what they see as Kenyan effort to continentalize a national problem. So the AU cannot impose mass withdrawal in its members. Ladies and gentlemen, would you give the 6-year-old child the chance to be more productive, or would you execute him? Thank you.
Okay, thank you very much for that speech. The speech time was 8 minutes and 8 seconds. So we will now welcome the second speaker from the proposition team.
Okay, I'll begin my speech in 3, 2, 1. False marketing, weak foundations, International Criminal Court. I've listed a series of synonyms. This speech will consist of 2 parts. The first rebuting each and every single one of the opposition's claims, and the second shedding to light more argumentation as to why our motion of countries leaving the ICC to put in place their own regional replacements is the better choice. First of all, my opponent chooses this analogy of a child. Allegedly, it's 20 years old and it's in development. First of all, it has only prosecuted 31 cases in its alleged 20 years of existence. I'd say that that's quite a significant list. This speech's critics isn't about its 20 years of development or what it's done or what it hasn't done, but rather in its constitution and its foundation. Yes.
You said that they only persecuted a few people, but
not few people.
Sorry, but were they going to be able to prosecute and give fair judgments if they had less time?
If they had
less time.
Bugged. Well, absolutely not. It's not considering time, it's considering the resources that they had, but they still didn't make the most of it, and you'll hear more about that in the later parts of my speech. Okay, so in its constitution, in its foundation, it was destined for doom and failure since its poorly drafted constitution, as this speech will show. Africa and my foster countries have plenty of human rights violations, but certainly not the most. Don't let yourself be fooled, ladies and gentlemen. The ICC targets Africa, but what about some of the human rights violations in South Sudan, Syria, Myanmar, Iraq, Afghanistan, the Philippines, and Yemen? She speaks of the ulterior motives for China. This is totally false, by by the way, the ICC has jurisdiction over the crimes that commence in ICC territory and continue into China, and is urged to legally act immediately to open investigation. It might be effective, fine, and my opponent can try to justify this by the analogies of a child or by trying to justify countries not signing as a conflict of interest. But how does she justify the absolutely weak foundations? She doesn't, because ladies and gentlemen, there is no valid justification for its weak foundations. The only thing there is to say is how urgent we need a regional replacement. The ICC has blah, 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 invested plenty of its given resources to advance in forensic medicine, the archaeology of mass graves, the identification of bodies or the tally of victims, and they have been performed by some of the top criminal pathologists in the world, but yet, when in court, these evidences are being refuted. Let us first consider the ICC's constitution and the Roman Statute's 5 principles. A, any person who commits an act which constitutes a crime under international law is responsible and therefore liable to punishment. B, immunity under domestic law is not applicable to a perpetrator of international crime from criminal liability. C, an individual who commits an international crime is accountable in international law. And D, any person charged with a crime under international law has a right to a fair trial. Thus far, there have been 31 cases before the courts. The better half of these alleged crimes all took place within a given country. How can judges trial and prosecute continental and national crimes if deeply chiseled within their constitution claim to only prosecute those who have committed international crime? It is, by the way, important to bear in mind that for a crime to be considered international or transnational, it must involve the crossing of borders or jurisdictions. Let us also scrutinize Clause A. Indeed, the ICC, as my peer has said in our first proposition speech, prosecutes crimes against humanity. More specifically, the ICC statute defines crimes against humanity as when committed as parts of a widespread or systematic attack directed against any civilian population with knowledge of the attack, include murder, extermination, enslavement, and the list extends. Let us also bear in mind those suffering from mental conditions, those who have, without proper consciousness, entertained occurrences leading to death, to violence, and the list extends. Let us consider one of the greatest and largest nations in the world, the US, where research suggests that individuals with schizophrenia, for instance, and bipolar disorders are responsible for approximately 10% of all homicides. For mass killings, the percentage is 33%. In France, where crimes attributed to mental illnesses are 18%. Of course, the US isn't a member of the ICC, but its vast population and demographic allows for statistics that can be applied to our claim. The ICC claims to have a goal to restore world safety and peace, yet marginalizes and doesn't provide the proper means for a faction of those responsible for crimes to get help. How can we restore safety and peace if we aren't implementing the needs of those in need that are threatening that very safety and peace in our constitution? If the opposition defends the ICC, I will ask that they provide an answer to my question to ensure that all factions responsible for crime get some form of endowment. If the latter hasn't already proved just how incompetent, vague, and paradoxical the foundations and constitution of the ICC are, I'm sure the following will. Let us consider the constitution, that in the constitution some clauses are to this day incomplete, such as the clause for aggression, which is inherently undefined and yet to be defined. Let us bear in mind that its embedding status haven't changed since the emergence of the ICC. It is absolutely clear that the ICC's constitution is in innumerable regards flawed, whereas regional replacement courts would allow for a new, enhanced constitution to be drafted and abided by. The ICC's Nuremberg Charter and Tribunal also speaks of international felonies, international atrocities, or international crime. The rationalization for the development of the rules, procedures, and courts that make up international criminal law, that they aim to provide the means through which people and society at large can find justice when norms are violated. But it's unclear what is meant by justice because it carries in itself a variety of assumptions. The ICC has, since its emergence, never cleared up what is meant by justice. I ask that the opposition either provides a definition for justice or justifies the lack of definition. In legalist international criminal justice discourse, justice is often assumed to be an objective notion, determinable and universal, this ideal that can be done and even delivered, in particular through a criminal trial. An understanding of justice as an objective notion suggests that justice means the same thing for different people in societies. Social psychological research, as well as research in communities that are affected by mass atrocities, shows that justice is inherently subjective and that social, psychological, and cultural differences, as well as diverse historical, political, and social contexts prevail regarding what is considered justice, for whom, by whom, how to choose one interpretation over another, and whose justice is taken into consideration at the cost of another's. The ICC doesn't consider this. The ICC proclaims and yells that we will encapsulate years of history, tons and tons of culture, nations' independent sovereignties, and generalize what is right to what is wrong. And therefore, externally with regard to different contexts and circumstances between societies, and internally with regard to differences among people within affected societies, different needs and wishes exist as to what would contribute to a satisfactory degree of justice for what was done to them. Hence, again, reinforcing the need as to why we need regional replacements for the ICC, that would contribute to a satisfactory degree of justice for what was done to them by greater comprehension of the select region. Let us also consider those prosecuting these trials are the 18 judges from 18 different countries, yet there exists a division of 124 countries in the ICC. Regional replacements would ensure a greater array of representation and of cultural comprehension, something that clearly isn't present or maintained by the ICC. Lastly, simply put, the ICC is inefficient. It strives for crime penalization. First of all, what's to say that penalization and mandatory jail time is the best option for crime? There, to this day, has been no studies led by the ICC proving that the aforementioned is psychologically and socially the best consequence to crime. A huge part of its constitution are therefore opinion-derived and not factually proven by any forms of studies. Regional replacements would call for a case-by-case study for all cases, acknowledging the nuances and perplexities of each case. Some crimes mandate group or clan assistance, isolation, and list sense. At least our constitution would be solidified and driven by research. More than that, to have a body that assumes there will be violence, there will be murder, and mass murder, there will be assaults is only so useless. Our regional replacements call for both crime acknowledgement rather than penalization, and also, and most importantly, for crime prevention. For the aforementioned series of reasons, I stand very, very proudly in this proposition, but most importantly, for the same uncontested and absolutely unassailable reasons are why you must stand in proposition as well. Thank you.
Okay, the speech time, excuse me, the speech time was 7 minutes and 33 seconds. All right, let's please welcome the second speaker of side opposition.
So I will start my speech in 3, 2, 1. First of all, Desmond Tutu is a prominent South African Nobel Peace Prize winner and human rights activist, and he stated that, and I quote, "African leaders behind the move to extract the continent from the jurisdiction of the International Criminal Court were seeking a license to kill, maim, and oppress their people without consequence." And we can't agree more on this statement regarding what our first speaker stated earlier. Africa needs the International Criminal Court's interventions, and the history regarding its creation, aka the merging of the Tribunal of former Yugoslavia and the Criminal Tribunal of Rwanda, shows that this entity is not only helpful, efficient, but also legitimate. But first, I will be giving answers regarding what my opponents just said. First of all, justice means giving each person what he or she deserves. So it's giving each person his or her due, but justice and fairness are used in interchangeably. So the notion of justice implies that more than one person will cooperate in a certain matter. And talking about the clause of aggression, the fact that it has
Point
not
of
been
information.
defined-
Point of information.
Yes. Yes.
If you were able to come up with and ratify a definition for justice, don't you think that some of the best judges in the world with Ivy League education, with the backgrounds in humanitarian and international law could have come up with the same definition? Because they're choosing to include this definition, and I want to know why.
Of course, they can come up with this definition, but how can you apply this definition when the African countries are not cooperating with us as the International Criminal Court? For example, the clause of aggression has not been defined yet. Why? Because we can't define a clause of aggression if the African countries are not cooperating with us. And I will talk about this later on. Instead of accusing the international...
Point of information.
Yes.
You just spoke about African countries and how they aren't necessarily cooperative, but just excluding the limitation that you're setting for yourselves with justice within the bounds of Africa. What about the definitions of justice in Asia, in Europe? Because the ICC includes countries from all over those countries. Why aren't they being binded to this definition of justice?
Because I'll talk about it in the next arguments that I develop, don't worry. So instead of accusing the International Criminal Court, we should most likely focus on why there isn't a certain cooperation between the International Criminal Courts and the countries of the world, and especially Africa. I will elaborate on this later. So the ICC isn't targeting the African continent, though my partner already debunked this false claim. Furthermore, the ICC is getting involved in cases beyond Africa. We have Palestine, who was accepting the jurisdiction of the ICC and acceding to the Rome Statute in January 2015. The prosecutor has opened a preliminary examination for atrocities in Palestine and East Jerusalem since June 13, 2014. Also, following the 2009 military coup of José Manuel Zelaya Rosales, the president of Honduras, the ICC instituted preliminary investigations on crimes committed during the post-coup period. However, on October 28, 2015, the prosecutor closed the preliminary examination, citing lack of reasonable basis to proceed with an investigation, according to the Office of the Prosecutor in 2016. Furthermore,
Point of
in
information.
2014, yes.
Don't you think there is a precedent for Western interventionism within South America, i.e. causing, for example, civil strife that may make endeavors of the ICC into South America a worthless endeavor?
If it is a worthless endeavor, why is the proposition team criticizing the fact that we are focusing only on Africa? We are actually focusing on countries other than the African boundaries that we are given and accusing and being accused of giving. So, for example, if we have Palestine, we have Honduras, but you also have Iraq in 2014 with the reopening of the preliminary examination, which aimed at analyzing alleged crimes attributed to the armed forces of the United Kingdom, who was deployed in Iraq between March 2003 and July 2009. And in fact, these preliminary investigations outside the African region serve to demonstrate the court's preparedness to take on cases beyond Africa, thereby dispelling the myth that the ICC only focuses on situations in Africa. So, the preamble of the Charter on Human and People's Rights states that signatories will, and I quote, coordinate and intensify their cooperation and efforts to achieve a better life for the peoples of Africa and promote international cooperation, having due regard to the Charter of the United Nations and the Universal Declaration of Human Rights, end of quote, and further recognizes that human beings are entitled to national and international protections. And these principles are further repeated in the African Union's Constitutive Act as its objectives, I quote, encourage international cooperation and promote and protect human and people's rights, end of quote, in accordance with the Charter of the UN and the UNDH. So these statements are clearly written and expressed by the African Union, but the ICC still gets false claims of neo-colonialism, but the reasons for the withdrawal aren't even because of this so-called neo-colonialism, but only with the selfish interests of a handful of heads of state in Africa. And we can't witness a domino effect if one state of two withdraw from the Rome Statute, since withdrawing is very costly, but it can also lead to cutback in development aid towards the African continent, which actually still needs it. In addition to that, very few African countries have in fact adopted the Rome Statute into their domestic law, but without such domestication, the ICC cannot prosecute criminals on a national level. It also shows a clear lack of political will by the African leaders to protect human rights and end impunity, which presents a paradox to the African Union's constitution, though some exceptions exist to confirm the rule, like the Habre trial in Senegal in 2016. And the ICC isn't here to put obstacles in front of the countries. They are here as a means of cooperation. The court may stand against amnesties, but the Rome Statute does not prohibit the amnesties at all. So looking at the main objective of the ICC as facilitating the end of impunity, amnesty would seemingly not be conductive towards this end.
Point of information.
Yes, yes.
So allegedly to you, the ICC serves to end impunity, but if I'm not mistaken, it was actually your peer that said that the ICC emerged in 2002, but yet in the years of 2004, of 2006, there was a genocide in Namibia. It is important to note that Namibia was a part of the ICC. The government of Namibia didn't do anything. So under those standards, shouldn't the ICC have taken some form of intervention to end the impunity?
I'm sorry to cut you off. I'm sorry to cut you off, but the POIs can only be 15 seconds long, and yours was about 30 seconds.
No, I was done. That's it. That was the end of it.
Okay, but you still reached 30 seconds.
Oh, sorry. She's still going to answer.
So for the question about the Namibia genocide, I will also say that I will elaborate later about an alternative for the regional courts. If you think that 2 years or 4 years is a lot to condemn some crimes, you will see later about the Pan-Africanist Court, which was actually met with failure. So first of all, the ICC is before all a jurisdictional institution, we all know that, and it bases its organization with resolutions on treaty law. But the Pan-African Court was met with failure because there was reluctance by the African states themselves in accepting the court's jurisdiction. How can the African countries cooperate with regional alternatives if they are reluctant towards the courts? So the protocol was adopted in 1998, but only came into operation 6 years later in 2004, after 15 states only had ratified it. And as of the beginning of 2014, only 27 out of a possible 54 African Union states have ratified the protocol. So the slow ratification would seemingly indicate a continued reluctance by African nations to subject themselves to the jurisdiction of the courts. And this doesn't bode well with the replacement for the ICC, which in fact has more African countries having ratified its treaty, 34 countries or 7 more countries.
I'm sorry, Rita, I'm gonna have to cut you off. You've reached the 9-minute mark. You're only allowed a maximum time of 8 minutes and 30 seconds.
The POI counts in the...
Yes, they do count.
Oh.
Okay, so I just want to make a few announcements. Announcement number 1 is you should accept at least 2 POIs. You can also accept 3. But accepting a little bit more than 3 is probably not preferable. Like Rita, you accepted 4. So that's announcement number 1. Announcement number 2 is just make sure your POIs, make sure you can ask that question or make that statement in 15 seconds or less. So if it takes you more than 15 seconds to ask your question or to make a statement, you're kind of like breaking the rules. So that's why, for example, I had to interrupt the last POI because she reached the 30-second mark and I was just like, okay, this is kind of like unfair. So yeah, just 2 pieces of announcements. You know, I understand this is your first, I think everyone in here except Kawtar, this is your first time doing a WSCC debate. So it's totally fine. Mistakes like that happen. It's part of the learning process. But just to be fair to everyone, I just want to make the announcement. So in summary, best thing to do is just to accept 2 POIs. Make sure if you ask a POI, it's 15 seconds or less. All right, let's continue because the next debate is starting in 13 minutes. Let's please welcome the 3rd speaker of the proposition team.
Thank you. My speech will start in 3, 2, 1. Well, the opposition team has given out excellent arguments. However, I will have to disagree because if I agree, then we'd both be wrong. And thus we want to reiterate our stance. We think that the member states of the ICC should withdraw to form regional criminal organizations. Why we think this is that the International Criminal Court has shown once and once again that it is an ineffective tool for prosecution because of lack of power enforcement, because it has siphoned funds away from impoverished nations that could have used it to actually enforce law in their own nations, such as Niger and other sub-Saharan African nations. And that transitioning towards regional justice organizations will allow military personnel to enforce more strictly and prosecute more strictly. And then one of our big argument is that the ICC has been a tool for neocolonialism. It has exhibited a clear bias towards ongoing investigations in African nations. And yes, please.
What you said that the ICC is like a new tool for neocolonialism. What about the fact that the majority of African nations self-refer the ICC's involvement, or the fact that African nations are the ones with the most human rights violations simply?
Well, we have spoken in our previous speech, if you had listened, about the fact that many of the human rights violation and instability in these nations is from Western intervention. Thus, Western nations are reprehensible for it. Thank you. We'd like to get back to our debate. Now, we'd like to ask the opposition team to not misunderstand and use our words wrongly, as I believe that Salma in the other team said that we alleged that the ICC was racist. No, we have said that the ICC exhibits a bias towards African nations. And that
POI?
no, thank you. And that to add to to add to many of these arguments against the ICC is a lack of representation. In fact, the ICC represents 124 member nations, yet only has 18 judges on a rotation basis. Thus, how can member states address the ongoing criminal and human rights violations in their nations if they don't even have a say? Now, the ICC cannot simply work because there is no such thing as international law. Cultural, economic, and social differences make it impossible to enforce law in an international level. Now that we've gotten that out of the way and reiterated, we'd like to address many of the arguments that the opposite side has made. Considering, first of all, that the ICC does not exhibit a clear bias towards African nations. So you pointed out the fact that after January 2016, there have been many ongoing investigations in other nations outside of Africa. Yet how is it that in 2022, 12 out of 21 ongoing investigations of the ICC have taken place on the African continent? After addressing this, we'd like to come back to an argument that the ICC is too young and not large enough to address crimes effectively. We believe that it is an argument in our favor, and we find it quite hypocritical that the opposition team uses the example of the Nuremberg trials, which inspired the ICC to speak about its success, wherein the Nuremberg trials took 1 year to address many of the war crimes that took place in World War I, yet in 20 years of its existence, the ICC has only convicted 10 people. It is an oxymoron. Now, to come back to this question of the Nuremberg trials, we don't believe that it is relevant to cite prior trials at an international justice system to justify that the ICC is effective, because they are different. They have spawned in different socio-economic, geopolitical contexts, and cannot be used to make accurate models of the world today. Now, one of the opposition team's strongest contenders was Rhita, who, from what I remember, had an appeal to authority as an argument, wherein they used the argument of a Nobel Prize laureate to justify that the ICC is an effective institution. We believe that it is irrelevant to the debates, and that in fact it hinders your arguments. So, what I heard from the opposition team, excuse me, is that a point of information?
Yep.
Yes, please.
Yes, you said that the fact that he is a Nobel Prize winner doesn't mean anything. Then what does the prize, like the Nobel Prize, which is the most like intellectually important award, means? Than not giving him like intellectual authority to give definitions and etc.
Thank you for asking that. Aung San Suu Kyi, who was the former Prime Minister of Myanmar, was a Nobel Peace Prize laureate, yet she was responsible for the Rohingya Muslim genocide. Thus, it cannot mean anything, because behind scenes, many of these characters hide tragic atrocities. Thank you. Now I'd like to come back. And what we heard is that there is no worth in many of these nations leaving the ICC because they would be exempted from the financial aid that has been granted to them before. And we think that's a manipulation tactics and reinforces the fact that the ICC is a tool for neocolonialism, because these nations, these impoverished nations like Niger or like Botswana cannot leave the ICC, because if they leave the ICC, then they will not receive humanitarian aid. That is basically a financial trap that makes it so that they could never join regional justice unions, which would serve them better in their goals. And we think that there has been a large focus on crime prosecution within the ICC, yet not enough focus on crime prevention, in that even in the task that it has specialized in, which is crime prosecution, the ICC has failed to show results. We'd like to reiterate with our statistic that in 20 years of existence, only 10 convicts have been arrested by the ICC. And thus, it would be much more effective for these nations to form regional agreements wherein they have more power, and they can be more effective since it is within the confines of their own nations. Yes, please.
It's protected time. You cannot ask a POI.
Oh, Already? Okay, sorry.
Well, I end my speech. Thank you.
You didn't have to end your speech because we were at 7 minutes and 14 seconds, but it's okay.
Can I still give my POI? Because
no, because you asked after the 7th minute, and the
Okay.
once we reach the 7th minute, it's protected time. All right, guys, I don't mean I just want to say this again. You guys should have watched the video that I've sent you. I hope you did, where I explain all the rules. And one of the rules is that the first minute and the last minute are protected time, so you cannot ask POIs during that time. But it's fine. This is our first debate. I'm sure we'll all adjust to the rules as we go along. All right, let's give the last speech of this debate, which would be the third opposition speech.
I will start my speech in 3, 2, 1. Ladies and gentlemen, during this debate, the proposition team has been continuously claiming that the International Criminal Court is only focusing on the African continent, and they also claim that it is an ineffective and illegitimate and biased institution. First of all, we would like to say that all of these accusations towards the ICC are completely absurd, because it's not a biased institution. It does not focus on the African continent, because the nations that have been investigated by the ICC have themselves asked for the ICC's involvement. So the ICC does not act without being asked. So therefore, it cannot be biased, because they do not pick and choose. They don't say, oh, we're gonna investigate their country. No, these countries have asked for some situations to be investigated. So therefore, the ICC is doing their job, and they're not, just focusing on the African continent. Plus, we all know that in the African continent, most of the war crimes, genocides, and human rights violations happen in the African continent. And the African continent is in urgent need for the ICC. It really needs the ICC's work for them to respect more human rights, etc. So the proposition team said that
Point of
they're only
information.
yes.
So you said that more nations need the ICC, for instance, because they need to respect more human rights. So you're talking about crime prevention rather than crime penalization, which is what the ICC does, because the ICC doesn't do crime prevention, it does crime penalization.
So I said African nations, especially, and all nations need the ICC's work, because of course crime prevention, but also crime punishment, because these countries do not have good justice systems. They do not punish criminals. Okay.
Point of information.
No, thank you. I'm gonna get back to my argument, to my speech. So the proposition team said that the ICC is only focusing on African countries, and they do not pay attention to other countries. Well, simply, they're not paying attention to other countries because these countries are not members or are non-state parties of the ICC. So the ICC has no rights and no power to get involved or operate in these regions, because they did not sign the treaty, and they're not members of the ICC. And in addition to this, powerful countries such as the US, China, or Russia are going against the ICC. So my question here is for the proposition team. Do you think if the ICC was inefficient and if it was illegitimate, countries, powerful countries such as the US and Russia, would they go against it? If they knew that that the court would not deliberately ignore such atrocities, would they just go against it and not sign the treaty? They know that the ICC is doing its job. They know that if they sign the treaty, they would be punished for the atrocities they're doing to people. So more African countries are being punished because a lot of African countries are state members of the ICC, while other countries are not. We have also mentioned, my teammates have also mentioned 2 impromptu tribunals that prompted the creation of the ICC. these two tribunals had the same role and the same mechanism as the ICC. Do you think if these two tribunals weren't efficient and weren't legitimate, would they, prompt to the creation of the ICC? So I think that it was only right to create one international court that would address war crimes and crimes against humanity and serve justice to the victims. We can say that this institution was a dream come true, because didn't we all wish for an unbiased, independent party that would serve justice and punish criminals? Because we've had enough of war crimes, of genocides, of human rights being violated. We want justice to be served. And this is what the International Criminal Court is
Point of
doing.
information.
Yes.
Don't you think it is rather inconsistent that the International Criminal Court has been prosecuting its own members in the African continent while ignoring the crimes such as ecocide committed by European members, notably?
As I said earlier, the countries that are not being punished are countries that are not member states of the ICC. So therefore, the ICC cannot punish them. So I'll get back to my speech. So instead of countries withdrawing from the ICC, we need to all cooperate, because this is a long-term serving justice is a long-term project, and investigating takes a lot of time. So the proposition team said that in 20 years of ICC's existence, they only prosecuted 10 people. I'm sorry, but investigation takes a lot of time. Would you rather have a fair judgment that's going to take maybe a long time, or a quick judgment that's not going to serve justice? And also, to prove my point that the ICC is not only focused on the African continent, there has been investigation going on. Yes.
Serving justice, but justice to what standards? To the standards of the international law?
Yes.
Okay.
So I was saying that, for example, investigation in Honduras, Palestine, and Iraq are proof that the ICC is not only focusing on situations in Africa, but it's doing its job as an international independent institution. Also, the PROC team defends the creation of a regional replacement. And we have proved, my teammates have proved, that it's not going to work. Because, for example, the Pan-Africanist Court was a failed attempt to create a regional replacement that did not work. And here we are proposing our alternative is to, for example, cooperate with, for the ICC to cooperate with regional courts and to find solution and to serve justice. And we give as example the memorandum that has been signed between the InterAmerican Court and the ICC, and that's been successful. Also, African countries or the African Union's Constitutive Act states as its objective encouraging international cooperation and promote and protect human and people's rights. And although these statements are clearly written and expressed by the African Union, the ICC still gets false claims of neocolonialism when it's not. The African Union is stating facts that they're not respecting, and then accusing the ICC of neocolonialism. This is not neocolonialism. It's just selfish interests of a handful of heads of states in Africa. Also, some African countries do not adopt the Rome Statute under domestic law. So it's not really benefiting them. It just shows a clear lack of political will by African leaders, to protect human rights and end impunity. So I think that we can all agree that ICC is doing its job, and that it's efficient and a biased institution, an unbiased institution, sorry. So for all of these reasons, we beg to oppose. Thank you.
Okay, the speech time was 8 minutes and 18 seconds.